out.
You don't need to tase me, dude.
Get out.
Hold on.
Get out now.
Hold on. You don't need to tase me, though.
Get out.
And I'm coming back to work,
Get out.
man.
Get out.
You don't need to tase me. Hold
Get
on.
out.
You
Walk back this way.
hang up the phone, though.
13, she's out.
Hold on.
Yes, put your phone down.
You
You're
don't,
not. Shut up.
Shut up.
Shut up. I'm done with you talking over me. Walk that way.
For what?
Now.
What for? Hold on. No. You don't need to forcefully. No, hold on.
You're going to get taken to the ground.
Hold on.
Stop.
Don't do that. Don't do that. Hold on, man.
Stop.
Hold on. Oh! No, I'm not doing it. Dude.
You can't resist.
I know, but dude, I gave him my ID.
On October 10th, 2024, Patrol Officer Lachlan Hicks radioed dispatch that he was stopping a blue Honda for going 40 in a 25. 9 minutes later, that same officer would be standing over a woman he had just thrown to the pavement, asking a colleague whether department policy would have let him tase her too. Somewhere between those two moments, a routine speeding stop became a case study in what happens when a badge treats a request for proof as an act of defiance. Picture a stopwatch sitting on the dashboard of that patrol car. From the first word out of Officer Hicks's mouth to the moment Cynthia Sanchez Rosas hit the ground, less than 2 minutes pass. That stopwatch is the entire...
Hello. I'm Officer Hicks, Lowell PD. I'm stopping you for doing 40 and a 25.
40 on a 25?
Yes, ma'am.
That's not true.
It is true.
That's not true.
Okay. Do you have your license and insurance?
Do you have the,
Do you have your license and insurance?
I do have my license and insurance.
Please produce it.
Do you have the evidence where I was running 45?
Please produce your license and insurance.
Do you have that?
Next time I have to ask, I'm going to arrest you for obstructing governmental operations.
You can't arrest me for
Yes,
that.
I can if you don't identify.
But do you have the...
Okay.
I will.
Step out.
Before we go deeper into what the footage and the Arkansas Code actually show, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence. Let's start with what actually happened, stripped of narration. Officer Hicks approaches the vehicle and informs the driver, Miss Sanchez Rosas, that she was clocked at 40 in a 25. She disputes it immediately. He asks for license and insurance. She questions the basis for the stop before producing it. Within seconds, Hicks tells her that if he has to ask again...
Where I was running 45.
Please produce your license and insurance.
Do you have that?
Next time I have to ask, I'm going to arrest you for obstructing governmental operations.
You can't arrest me for that.
Yes, I can if you don't identify.
But do you have the...
Okay.
I will.
Step out. Nope. You wanted to play
Amber?
games.
Hold on.
Nope. You wanted to play games. Yes, I can. You wanted to play games.
No.
Get out.
Hey, you
Get
can't
out of the
do
car.
that. No.
Get out of the car.
No. Hey,
Get out of the car.
I'm giving you my...
Get out of the car.
ID.
Get out of the car.
I'm giving you my ID.
1394. Get out of the car.
I'm giving you my
Get out of the
ID.
car.
I asked for proof. I'm giving you
Get
my
out of the
ID.
car or you're
You
going to
don't
get
need do
tased.
that. You don't need
Get
to
out
do
of the
that.
car.
Hold on. You don't need to do
13,
that.
I got one trying to block me from the seatbelt.
I'm not trying to block you from the seatbelt.
She wouldn't let me get her out. She's
hold
just
on,
not
hold on,
listening
hold
to
on.
instructions. She's
She will be arrested for obstructing governmental operations. She begins to hand over her ID. He orders her out of the car. She continues reaching for the door as he repeats the command. He warns her she is about to get tased. She exits. He tells her to walk toward the rear of the vehicle. She asks why. And within moments, he has grabbed her, leg swept her, and taken her to the ground.
Yeah, I gave him my ID.
You can't
I know,
resist.
dude, but I gave him my
I
ID.
know, just stop.
Like, I gave him my ID. Hold on. Hey, can you go tell Amber that I'm being taken, please? Yeah.
Okay.
And my ID is right there. I need my phone.
Just calm down.
Yeah, but like,
It's right
14.
I know, but like, I gave him my ID. I asked him for proof that I was going 45 on a 30, which I wasn't.
You made that way bigger than it needed to be.
Yeah, but I was not going 45 on a
Get out.
30. This is not necessary, man.
113, log 1 resisted.
I was not resisting, dude. I gave you my ID. I was not going 45 on a 30. Dude, I'm getting back to work.
Not anymore, you're not. You're going to Benton County.
Oh my God.
You work here.
Yeah, I was not going 45 on a 30.
You're doing 40 and a 25.
No, you first said 45.
No, I didn't.
Yes, you did.
You can
have
FOI the
that
body
proof?
camera.
Okay. And I asked you for proof.
You're under arrest.
Okay,
You're under arrest for obstructing governmental operations.
She is arrested and charged with speeding, obstructing governmental operations, and refusal to submit to arrest. Here is where the forensic gap opens up. Under Section 27-16-601 of the Arkansas Code, a driver is required to produce a license on demand during a lawful traffic stop, and that obligation does not hinge on the officer first proving the violation to the driver's satisfaction. The Supreme Court's 1977 ruling in Pennsylvania v. Mims further establishes that an officer may order a driver out of a lawfully stopped vehicle as a matter of course, no additional suspicion required. So, on paper, assuming the underlying stop was valid, Ms. Sanchez-Rosas was legally obligated to comply with both the license request and the exit order. That much is not in dispute. But obligation to comply and criminal liability for delay are two entirely different legal questions, and this is where Officer Hicks's own body camera starts working against him. Compliance is not a crime. That's the first time you'll hear that phrase in this video, and it will not be the last.
I was not obstructing
Resisting
nothing.
arrest
I was grabbing my wallet.
And speeding.
I was not speeding either.
Sit down. Your car's also getting impounded.
Officer Hicks informs Ms. Sanchez-Rosas that she's under arrest for obstructing governmental operations, resisting arrest, and speeding. Ms. Sanchez-Rosas disputed the alleged speed.
Hey, Ben, you're good. You're good.
I don't know where her... Thanks, bud. Her glasses got bent up. Yeah, I don't suspect that. She's just speeding. Made it way bigger than it needed to be. 10-4. That'll be the subject I'm 15 with. So, okay. It's all taken care of.
Did you get speeding, obstruction, resisting?
Yeah. So, question.
Yeah.
And this is, as I understand the policy, I would have been green light to taser. But want to understand in this specific scenario. So she finally gets out after the warning. I holster the taser. We're talking. She's arguing. I tell her to walk back this way. She refuses to do it. I go to grab her. She pulls away. And she I go to grab her again to armbar. She's strong arming it and won't comply at all.
Yeah.
But this one, I think I made the right choice.
That's active resistance, which in a situation you could, but like Garcia said, we should.
Section 5-544-102 of the Arkansas Code defines obstructing governmental operations as intentionally obstructing, impairing, or hindering a public servant's performance of a governmental function. The Arkansas Court of Appeals was explicit in the 2026 case of Caton v. State. The statute requires actual interference with law enforcement operations, not mere hesitation or verbal pushback. A driver who argues about the basis for a stop while still handing over identification is not obstructing anything. She's talking. Talking is not a governmental function under siege. Now picture the visual anchor again, that stopwatch on the dash. At the 50-second mark of this encounter, Ms. Sanchez-Rosas is already reaching for her ID. She hasn't refused. She's questioning. And under the standard the Arkansas courts have laid out, questioning while complying does not meet the threshold for obstruction.
Went to go get the seatbelt. Well, she blocked me from getting it. And so I was pulling the taser out. I hit the warning. She's like, all right, you don't have to tase me, dude. You don't have to tase me, dude. But then, in reality, I could have taser with that one, but it just wasn't.
Yeah, the warning worked. Look at that.
Yeah, well, until we started having to wrestle on the ground.
Officer Hicks tells the other officers that he would have been within his authority to deploy his taser against Ms. Sanchez-Rosas.
That distinction, asking why versus refusing to act, is the entire case. And it's a distinction Officer Hicks does not appear to have made in real time. So let's get to the moment that actually matters, the taser. Here's the ticking clock question, because this is where a routine stop stops being routine and starts being a constitutional test case. What happens in the 3 seconds after an officer decides that a driver's confusion is the same thing as a threat? Officer Hicks tells his colleagues afterward that he hit the warning on his taser, and that, in his words, he could have deployed it for real.
We shouldn't rely on the taser.
Yeah, exactly.
You can fight her.
Yeah. Yeah. I just want to make sure.
But yes, that's active resistance.
Okay. That would fit the policy if somebody was to ask. Yeah. Okay.
But yeah, that's cool. The warning, that actually got her. That's kind of cool.
Yeah. She was like, oh, yeah. You'll see it on the body cam.
Officer Hicks asks another officer whether departmental policy would have authorized taser deployment during the physical struggle, and the officer states that it would, characterizing Ms. Sanchez-Rosas's conduct as quote-unquote active resistance. Now, while the department's taser policy is not publicly available, the legal distinction between active and passive resistance is well established. As the 8th Circuit Court of Appeals explained in the 2020 case of Cohorst v. Smith, the failure to follow police instructions may constitute passive resistance. And when a suspect is passively resistant, some lower level of force may be reasonable. Likewise, in the 2017 case of Tatum v. Robinson, the 8th Circuit made clear that non-compliance and arguing alone do not amount to active resistance, and that physically struggling, threatening an officer, or attempting to flee are the kinds of conduct that distinguish active resistance from passive non-compliance, with active resistance generally permitting a greater degree of force and response. To the extent Ms. Sanchez-Rosas physically opposed Officer Hicks during the struggle, a court could potentially find that her conduct crossed the line from passive noncompliance into active resistance under that framework, which could potentially justify a higher level of force and response.
Yep. Cool. I'm gonna go ahead and transfer her to Benton County.
Okay. All right. I'm good. I'll do your.
He frames this to another officer as textbook procedure. Ask a question, get an answer, move on. But courts don't grade taser deployments on an officer's internal sense of what he could have gotten away with. They grade it against the Fourth Amendment's objective reasonableness standard from Graham versus Connor, decided in 1989, which weighs the severity of the alleged crime, whether the suspect poses an immediate threat, and whether she is actively resisting or attempting to flee. Run Ms. Sanchez-Rosas through that test.
That'll be the subject I'm 15 with. So,
Okay.
It's all taken care of.
Did you get speeding, obstruction, resisting?
Yeah. So, question.
Yeah.
And this is, as I understand the policy, I would have been green light to taser. But want to understand in this specific scenario. So she finally gets out after the warning. I holster the taser. We're talking. She's arguing. I tell her to walk back this way. She refuses to do it. I go to grab her. She pulls away. And I go to grab her again to armbar. She's strong arming it and won't comply at all.
Yeah.
But this one, I think I made the right choice.
That's active resistance, which in a situation you could, but like Garcia said, we shouldn't. I mean, you, the female, we shouldn't rely on the taser.
Exactly.
You can fight her.
Yeah.
Yeah.
I just want to make sure.
But yes, that's active resistance.
Okay. That would fit the policy
Yes.
if somebody was to ask.
Yeah.
Okay.
But yeah, cool. The warning that actually got her. That's kind of cool.
Yeah. She's like, oh, yeah. You'll see it on the body cam.
Officer Hicks asks another officer whether departmental policy would have authorized taser deployment during the physical struggle, and the officer states that it would, characterizing Ms. Sanchez-Rosas's conduct as quote-unquote active resistance. Now, while the department's taser policy is not publicly available, the legal distinction between active and passive resistance is well established. As the 8th Circuit Court of Appeals explained in the 2020 case of Cohorst v. Smith, the failure to follow police instructions may constitute passive resistance. And when a suspect is passively resistant, some lower level of force may be reasonable. Likewise, in the 2017 case of Tatum v. Robinson, the 8th Circuit made clear that non-compliance and arguing alone do not amount to active resistance, and that physically struggling, threatening an officer, or attempting to flee are the kinds of conduct that distinguish active resistance from passive non-compliance, with active resistance generally permitting a greater degree of force and response. To the extent Ms. Sanchez-Rosas physically opposed Officer Hicks during the struggle, a court could potentially find that her conduct crossed the line from passive noncompliance into active resistance under that framework, which could potentially justify a higher level of force and response.
Yep. Cool. I'm gonna go ahead and transfer her to Benton County.
Okay. All right. I'm good. I'll do your inventory. I'll email you, and then it's all in Keyser, and it's not a push to start.
Yeah. 10-4. If you would have sent me a CR for obstructing governmental operations. You have the car key?
I've got it, yeah.
Okay, cool. Real quick, there's no arguing it. You are going to Benton County, so don't start with that. But do you need medical assistance for anything?
No.
Okay.
Did you pick up my glasses?
Yes, I got your glasses, your phone. Your car key is going to go with the tow truck, but we got the keys off the car key itself.
Does it need to be towed since I'm at work?
Yes, it's going to be towed.
What's up? Oh, all right, I'll take care of your record and.
The underlying offense was a traffic infraction. Speeding. Not a felony, not a weapon, not a flight risk. She made no threatening movement toward Officer Hicks. She was, by every account, including his own recorded statements to colleagues, arguing and delaying.
Not safety. Whether that threat would survive Fourth Amendment scrutiny is, at minimum, an open question. Additionally, Officer Hicks failed to exercise sound discretion, moving to physical force swiftly and without any attempts to de-escalate the encounter. Ms. Sanchez-Rosas delayed in producing her license and questioned the basis for the stop, but the footage does not show a stated refusal to comply. Officer Hicks moved to initiate a physical removal without pausing to allow her a substantial opportunity to respond. And the encounter deteriorated to a physical struggle and a takedown within seconds. Even setting aside the constitutional questions entirely, an officer retains discretion in how they manage a non-compliant traffic stop, and nothing in this encounter suggests that Officer Hicks made any effort to de-escalate the situation down before resorting to force. A brief, measured attempt to give Ms. Sanchez-Rosas time to comply may well have resolved the encounter without physical contact altogether. This interaction highlights that lawful authority and sound professional judgment are not the same thing, and that an officer's failure to exercise the latter can turn a routine traffic stop into a far more serious encounter than the situation required. Ms. Sanchez-Rosas gets a C for failing to comply with lawful orders during a traffic stop, prolonging a routine encounter through non-compliance, and physically resisting Officer Hicks after she exited the vehicle. And while Officer Hicks's conduct raises legitimate constitutional concerns, Ms. Sanchez-Rosas' actions also contributed to the deterioration of the encounter. As established earlier, a driver is legally obligated to produce their license upon demand in a lawful traffic stop and to exit the vehicle upon command, and neither of those obligations is conditioned on the officer first justifying the stop to the driver's satisfaction. Ms. Sanchez-Rosas disputed the alleged speed throughout the encounter and repeatedly demanded proof of the violation before she would comply, but the side of the road is not the appropriate venue for a challenge to the validity of a traffic stop. The legal system provides mechanisms, including contesting a charge in court, and a driver who disagrees with the reason for a stop is generally better served by complying in the moment and litigating later. And finally, the physical struggle presents the most serious concern. Regardless of whether Officer Hicks escalated prematurely, Ms. Sanchez-Rosas' physical opposition potentially exposed her to criminal liability. However frustrating a police encounter may feel in the moment, it is essential to understand that physical resistance carries legal consequences that a courtroom challenge does not, and that the decision to contest a stop on the side of the road rather